meeting with me today, Ashley. I'm here with attorney Ashley Peterson. Ashley's practice specializes in real estate, probate, and business law. And my dear friend Dawn Ulrich, she's also a real estate agent. And we're just hanging out today, getting Ashley's opinion on dual agency. So I always like to stay updated on the best way to represent my clients. And I actually saw a webinar for the California Association of Realtors that I signed up for, and I sent it to Ashley, and I said, hey, what do you think about this? Because when you're representing both the buyer and the seller, you have a responsibility to protect the interests of both sides. So, there's been cases where I've run into other agents where they didn't disclose everything, or they could set themselves up for a lawsuit later. So it's going to be interesting to see how that law changes if you're not allowed to represent a buyer and seller anymore, and each side have to have their own agent. How is that going to impact, the real estate market?
Right.
So can you summarize that case for us and just tell us a little bit about, what your thoughts are?
Sure. So the case is, I'm probably going to butcher the name on it, but it's Horiki versus Coldwell Banker Residential Brokerage Company. This was a case that went all the way up to the California Supreme Court, and it was decided in November of 2016, so very recently. The way that the case was, the reason the case came before the court is because we had a seller who was selling a property in Malibu from a trust, and they hired an agent from Coldwell Banker in Malibu to act as their agent for the seller.
Mm-hmm.
And the seller's agent listed the property and all the marketing materials as being 15,000 square feet. And so that was what they marketed as. That's probably what they listed the price as, based on the square footage of the house.
Which, by the way, when you're listing a house, there's a couple different sources that you can claim where you got the square footage. It's either going to be the owner, the tax assessor's records, or a previous MLS listing. But it's really the buyer's responsibility to verify that information, right?
Right. So during the due diligence period, the agent for the seller actually pulled all the property tax records, and the tax records showed that the property square footage was actually closer to 9,400 square feet, which is a big difference from the 15,000 they were marketing it as. So they ended up getting a buyer who was interested in the property, and Coldwell Banker also represented the buyer. So we had Coldwell representing both the seller and the buyer, so we had a dual agency representation going on in this case. This agent who represented the seller did not disclose to the buyer that there was this discrepancy in the square footage of the property, but he did provide him with a copy of the property tax record. So they kind of went with the interpretation that it was up to the buyer to figure out what the square footage actually was, and that they needed to hire their own appraiser to figure that out.
So the agent showed them the report, but he didn't specifically point out, hey, there's a discrepancy here in the square footage.
Right. He just kind of let it slide, and I'm sure that was probably because he wanted the commission on the house,
Mm-hmm.
Especially if it's in Malibu. I'm sure it was probably a multi-million-dollar property. So obviously the buyer closed escrow on this property, and then subsequently was trying to do remodels and stuff, and found out that the square footage was actually closer to 9,400 and not the 15,000. So he sued Coldwell Banker and the agent, claiming that the agent breached the fiduciary duty to him by misrepresenting the square footage of the house. So that's how this case came about. The trial court actually ruled in favor of Coldwell Banker, and said that the agent was only representing the seller and not the buyer. Mm-hmm. It got appealed to the California Appellate Court, and then the Appellate Court found in favor of the buyer and not Coldwell Banker. So they reversed the trial court's decision, said there was a dual agency going on, and there was dual representation and duties to both sides. And so then the Supreme Court then heard it as well, and they affirmed the Appellate Court's decision. So in this case, the ultimate court decided that when you're a dual agent, whether you are representing both the seller and the buyer, you have a duty to disclose all material facts that are known to you that affect the value or desirability of the house, whether good or bad. So because Coldwell, the arching broker, represented both the buyer and the seller, even though the agents were different, there was still a duty to both the buyer and the seller to disclose all those things. So they should have disclosed the discrepancy in the square footage up front and made that very apparent to the buyer.
So, so when you're an agent who's like, for example, I was telling you about the buyers that I had met in an open house. They were falling from escrow, and they were previously in that escrow represented by the listing agent, who they just went directly to the listing agent to make an offer. I find that happening more a lot, where people will just go into an open house, or they'll talk to the agent that's listing the property and make an offer directly with them, somehow thinking that they're going to be able to save money on the commission or reduce the purchase price if there's not two agents. But the reality is, it doesn't cost the buyer anything to have their own representation, because the seller's the one paying that commission, and it only benefits you. I'm not saying that you can't be well represented by a listing agent, because I list property and I know that I could fairly represent a buyer. But I also understand that there's risks in me doing that, because it's very difficult to get your seller the most amount of money and to get your buyer the cheapest price at the same time. People are going to have to come to an agreement, and everybody's going to have to accept that they're paying fair market value or receiving fair market value.
Right, exactly. Yeah, I think it's a very difficult position to be in, to represent both the buyer and the seller, because like you said, there's that conflict. I mean, you want to get the highest commission for yourself, so obviously you have a personal interest, and then you also have a duty to represent the seller to make sure they get the highest price. But if you're representing the buyer, they're not going to want to pay top dollar either. So
Right.
Where do you find that happy medium, you know?
And in the escrow that was falling with the client that I met, they were falling from escrow because they went to do their due diligence and found out that there was a crack in the slab. Well, the listing agent had the listing for over a year, and when they first listed it, there was old carpet. You know, all of a sudden they take it off the market, they put in new flooring, they put it back on the market, and supposedly the agent doesn't know anything about a cracked slab until it's time to do inspections, and they fall out of escrow, and they want the agent to at least be responsible for paying for their inspections, if nothing else. I mean, and they certainly don't want to lose their earnest money deposit because they weren't well represented by both sides.
Yeah, the most common number of lawsuits are based on real estate agents not disclosing something that they knew about, and the buyer figuring that out after the fact. So, you know, always use the phrase, when in doubt, always disclose everything, you know, and it's better to be over-inclusive than under-inclusive, because that's where you get in trouble.
And to you know, just to be aware of the agent that's representing you, because there are agents out there, unfortunately, that they're only closing 2 or 3 transactions a year, and they might not be making the best decision about what's in their buyer's best interest or their client's best interest, because if they lose that deal, they don't know how they're going to pay their bills the next 3 months.
Right.
So it's not to say that you can't work with an agent that's not experienced, but make sure that your agent's being subjective about their behavior so that it's in the client's best interest and not just worrying about their own commission.
Yeah, exactly. And it's definitely not recommended to be both the dual agent for the seller and the buyer, because you're probably going to get into hot water at some point, you know, doing that.
So do you anticipate that law changing in the future, or dual, because in other states, like Dawn was mentioning, in Texas, what's the dual agency in Texas?
In Texas, there is no dual agency. It's not allowed. It's actually illegal for you to have dual agency. They have what's called intermediary representation. And so in that instance, the buyer, if a buyer and a seller have the same agency, have the same representation, then the head representation must not advise or give advice or opinions regarding the sale or the purchase of that house to those 2 people. They can't do it. So they have to put intermediaries in place in order to be able to do it.
Right.
And the intermediaries are able to then give advice and opinions to their own person, but they can't talk amongst one another about the situation. They just can't. It's illegal.
Yeah.
Yeah. So
I don't think California will go that direction, because we were actually one of the few states that actually did make dual agency legal.
Right.
You know, probably I think it was over time. I think it was in the 90s that happened, but don't quote me on that. So I think we'll allow it, but obviously the standards are getting stricter on the fiduciary duties that are imposed for both sides. So that's going to be the most important thing, I think, is complying with those fiduciary duties, and the courts are going to interpret it very strictly going forward, I think.
Yeah, so what's the best way for an agent to protect themselves if they feel like they're doing their best to represent a buyer and a seller in the same transaction? other than, I mean, just disclosing everything you possibly can disclose and documenting the file probably.
Yeah, definitely. I think both of those things are key to making sure you're doing everything, up to snuff and in compliance with all the laws. And, definitely, obviously disclosing everything no matter what, even when you're representing both sides and it may hurt your ultimate commission or your sale price.
Mm-hmm. Well, it definitely makes me rethink, like, okay, if I'm representing a seller now, is it the best thing for me to, if I have an open house and I need a buyer, say it's great to meet you, here's an agent that I work with that can represent just you as the buyer, and let's work together and make a deal. Is that a practice I should start implementing? Like, it just makes me think, what's the best way to protect my business or serve my clients?
Yeah, I mean, from my perspective, yes, I think that makes more sense to have someone on both sides so that it's completely fair and no one's going to question anything in that transaction.
Mm-hmm.
But, I mean, obviously I understand there's a lot of money at stake when you're doing a dual agency.
Right.
So, I mean, I would just be very, very careful if you do go forward as a dual agent that you are, being exactly like you said, disclosing everything, papering the entire file so you have everything well documented. Even your communications with your client saying,
Mm-hmm.
hey, what about this, and this, or is there anything else that you know of that I should be aware of,
Mhm.
and making sure you pull the property files and the records. And you said, Lynette, that you do this in your own practice, which is phenomenal. Going in and measuring the square footage of the house yourself,
Mhm.
kind of just a rough estimate, obviously, but
Mhm.
that's
I mean,
huge
it will
too.
tell you if you're 1,000 square feet off,
Right.
for sure.
Because I mean, 15,000 versus 9,400. I mean, you're easily going to figure that out
Right.
if you do a quick walkthrough measurement of the house. So.
Well, what's a more common issue than having a huge discrepancy like that is whether or not the square footage that's actually there is permitted.
Right.
So
Yeah.
they add in a granny flat or they
Right,
build on
and
a
they don't-
garage and they say, oh, it's 4,000 square feet, and then you go to the tax assessor and it's 1,800 and half of it's illegal that you
Yep.
have to tear down if you want to get it permitted.
Right.
So
And
that's a more common
yeah.
occurrence.
And that's why you want to get an attorney involved early on and ask for the advice of an attorney that does real estate, because then we can help you at least figure out what's permitted, what's not permitted, what you can do going forward, and whether that buyer is going to be able to do anything with the property that they're anticipating doing based on what they have in front of them.
And like
So-
what you said, have a real estate agent, even a good one, is not a real estate attorney.
Right.
So I'm gonna get that preliminary title report when we go into escrow, but I won't take on the responsibility of interpreting that for
Right.
you.
Right.
I can tell you if there's anything in here I think might be a red flag, like an easement or a lien.
Right.
At that point, you need to go and if you're buying $1 million property, paying for a consultation for an attorney during
Yes.
one point during that transaction could potentially save you thousands of dollars. I mean,
Absolutely.
Or-
especially if there's liens or easements or things that the seller's not even aware of, or that have been recorded from several years ago, that affect what they can do with the property. Because maybe if there's an easement, they can't build on that area, and that may significantly reduce the square footage they're thinking they can build on the property.
mm-hmm.
So yeah, I absolutely agree. I think if you have anything questionable on the title report, that you get an attorney's interpretation up front right away.
Mm-hmm.
And I think that speaks to the quality of the agent that you have as well.
Yes.
Because if you have a really great agent, then your agent is going to have allegiances with quality people, quality attorneys who could actually benefit both during the entire transaction. And
Absolutely.
that's just what makes sense.
Yep.
That's just what makes sense.
Mm-hmm.
Yeah, I completely agree with that.
Well, thank you for giving us your updated opinion on dual agency.
Absolutely.
I always love to hear your opinion, and I value it because, I get to pick your brain, and, a lot of people pay a lot of money for that, and I get to just bring you pizza.
Hey, I get paid in food, that's fine.
So if anybody wants to get in touch with you or learn more about, using your services or getting your help, what's the best way for them to reach you?
They can call me at my office. My number is 619-222-7300. Or you can go to my website, which is ashleypetersonlaw.com. That's ASHLEYPETERSONLAW.com.
Perfect. And I'll put the links here in the YouTube channel and when we put it on social media and everything. Make sure to like Ashley's business Facebook page. She's always posting awesome articles there that, keep me up to date on what's going on and with your business. And so thank you. We appreciate your time.
Thanks, Lynette.
Yeah, we'll see you guys soon. Have a good day.
Bye.
Bye.